Good morning, good evening, good afternoon. Happy Tuesday. I've given some thought to this. I looked at all the comments on my last video about Earl, and I feel like people aren't understanding my point. And I get it. A lot of people know a lot of things about Earl that they think applies to the situation. A lot of people don't like Earl. I don't like Earl. I've been on record as not liking Earl from the get. The thing is that I look at Earl's trial like a lawyer. And I look at his trial and I see some huge issues in it. It's been a long time since I've read the transcript. It's been a long time since I've looked at the documents. So, take all of this with a huge grain of salt. And let me preface this. Earl is a congenital liar. Everything that Earl says is false. Before the trial, I am on record as saying that because Earl is denying that he did it, I think he did it. That was my default position going in. Now, Earl didn't testify at his trial. And the jurors don't know that he's a congenital liar. And it's irrelevant to anything because he didn't testify. So there was no impeaching him, no showing his long history of saying the exact opposite of the truth. His prior acts, his prior convictions, I don't believe that they were introduced at trial. And since there was no sentencing hearing where they would be introduced, the jury wouldn't know about that stuff either. All the jury had is the evidence that was presented. And so I'm looking at this. If I was a juror, would I have a reasonable doubt? And my recollection of the trial is that the only percipient witness, the only person who saw, heard, whatever, anything related to sexual assault on the victim. I'm going to call the victim and not the alleged victim because there has been a trial and he has been convicted, which is why I'm using that terminology. It's not any statement on Earl's actual guilt or innocence. He's been found guilty. I understand that. I understand the process. That was the only real evidence. There wasn't any contemporaneous evidence that I recall being introduced that he had assaulted her. I think it was like almost every night for a year. I believe that was the testimony. It was like basically every night for a year. Again, it's been years since I've read the transcript. So, take all of this with a grain of salt. I'm not giving you the facts of the trial. I'm giving you my recollection of what the transcript said. Okay? So before everybody goes all in the comments, this is my best recollection. The contradicting evidence is that not a single person testified that they heard or saw anything like that. So if I remember correctly, I know the son testified. I think the wife testified. Neither of the two sisters testified that they saw anything. And remember, this was a mobile home. It wasn't that big. And there were, besides Earl and the victim, there were 4 other people living there. And it was like a 2-bedroom mobile home. And I believe the son's testimony was that he was on the couch. Now, people are going to say, oh, well, the son is going to protect Earl. Well, that's a thing to say, except the son would also have an interest in protecting his sister. And the mom, who also, I believe, if I recall correctly, testified on Earl's behalf that she didn't see anything, would also have an interest in protecting her sister. So their testimony would create, for me, a reasonable doubt. That doesn't mean he's innocent. That doesn't mean he's guilty. But remember that the standard is that the prosecution has to prove their case beyond a reasonable doubt. So as long as a juror could have a reasonable doubt, or should have a reasonable doubt, and I think in that instance it would be reasonable to say, well, it doesn't make sense how someone can be sexually assaulted basically every night for basically a year and no one in the house knows anything, cries for help, just the sound of the fornication, the sound of struggle, anything like that, would cause for me a reasonable doubt. And then I look at the trial and I see all of these other little things. The testimony about Earl being a Mormon and talking to his daughter about wanting her to convert to Mormonism so he could marry her. Not only does that not make sense, I mean, the part of me that knows Earl is a congenital liar could see Earl saying that. I want to be clear about that. But remember, Earl never testified. And Earl was never impeached on the stand. And so the jury can only look at this through what was presented. Now, Earl's religion or religious proclivities is something that should not be introduced. Being a Mormon doesn't and shouldn't make it more or less likely for you to sexually assault your daughter. Now, I'm not a Mormon expert, whether or not Mormons have some allowance to marry their daughters. I've never heard of that. But you can't say, well, this person is a member of this religion, because you have to remember that religions are divisive. And some people might just not like a religion. And so it's prejudicial to introduce that. Whether you think so or not, it's been found in various cases that I've covered in the past that is prejudicial. And so the prosecution shouldn't have brought it in. The defense, I think, objected, but too late. Or their objection was overruled. I don't remember exactly, but there was an objection, Peter Coventry. But I believe that there was a issue with it, if I remember correctly. The testimony, there was testimony introduced about Earl not wanting his wife to live in the house because she was pregnant with a baby that was fathered by a black man, African American. I assume it was African American. Maybe it was like an actual African. I don't know, but by someone of the black race, whatever you want to call him. And there was testimony introduced. He didn't want her there simply because she was carrying a half-black child. Now that is also highly prejudicial and has no bearing on whether or not he would commit sexual assault or whether or not the sexual assault happened. So it's highly prejudicial and not very probative. And again, I believe there was an objection made, but I believe it was made too late, or it was brought up in the closing arguments or something. I don't remember exactly how it was, but there was an objection, or there should have been an objection. I'm not sure entirely which, because there were some objections that the defense counsel made inappropriately, and there were some that he didn't make and he should have, and I don't recall exactly which ones were which. But if an objection wasn't made, that is evidence towards ineffective assistance of counsel. Now, whether or not it actually arises to the point that it rendered all of the assistance of counsel ineffective is a different argument. And again, I went into this, I said Earl has a very low chance of success on his appeal. And I went into this saying he has a very even lower chance of success on the motion for reconsideration. And I will continue to say that any further appeals, petitions for writ that he makes have an even lower chance of success. the chance of success drops at each step of the way. But I'll get into the I think I already covered. He can petition for writ to the highest court for criminal appeals, the Texas Court of Criminal Appeals. Once that is unsuccessful, and it most likely will be, almost certainly will be, but there's always a chance, then he can petition for writ of habeas to the federal court system. Yeah, I think he has a better chance of that than he has of winning the petition to the Texas Court of Criminal Appeals. He has a better chance of that, but only slightly. And then as he marches up the federal courts, the success chance continues to drop. So he has very low odds of getting any success. I just want to be clear about that. But the evidence about the alleged exclusion of mother from the home had no bearing on the sexual assault and was highly prejudicial, and that may have been enough to get the jurors past that reasonable doubt, just their dislike, their distaste for what the man did, not related to the alleged sexual assault, because there was a conviction, might have swayed them inappropriately to get past that particular issue. There was another issue that I thought was a big problem, was the testimony of the investigator. His testimony, and I'm almost positive there was an objection to this, but it might have been too late. Again, your mileage may vary. His testimony was that he interviewed the victim, and that he believed the victim, and he found her to be trustworthy. Now, the only people who are supposed to judge whose opinion on the truthfulness of a witness's statements is the jury. The jury is the only group who is supposed to have any meaningful decision on who is and who is not trustworthy. But there is a issue with having an investigator who has been established as an expert give an opinion about the ultimate credibility of a witness, because it is in effect substituting his finding of credibility for the jury's finding of credibility, because humans are humans. And I'm not saying this happened, but there's a reason why experts aren't allowed to testify as to the ultimate truth or veracity of something. And that reason is because people tend to believe experts. I mean, you have an argument on COVID vaccines, have an argument on the assassination of Charlie Kirk, have an argument on anything, and both sides will try to say, well, the expert said this, blah, blah, blah. Are you arguing against the official testimony? They're experts. The expert said that the 9/11 towers fell due to the impact of the airplanes, blah, blah, blah. The experts say this. People tend to believe experts. Someone who's been qualified as an expert, who's been held out as an expert. And so that can taint the ultimate decision by the jury, because 1, 2, 3, 5, who knows how many jurors may have been persuaded by that testimony. Those were the really big issues that I saw. And again, why would a jury, unless they I mean, it is possible that they entirely believed the credibility of the victim, and they entirely believed her story, and they didn't believe the other testimony that, I didn't see or hear anything, it's a mobile home, thin walls, not, this isn't a mansion with like soundproof walls. This is a mobile home. If you've grown up poor, you know what a mobile home's like, where there are 4 other people living there besides the the defendant and the victim, and none of those four people saw or heard anything specifically related to the sexual assault. It's a reasonable doubt. Now, you might believe the victim, and that's great. That's great. But, like, they're like some of the biggest voices, some of the most adamant people are people who had a real issue with Earl outside of this. They had a real issue with Earl before these allegations came out. And you being persuaded by it doesn't mean that a person who is outside of this small microcosm of YouTube would be persuaded by it. And so when I say I have doubts, what I mean is I have a reasonable doubt based solely on the evidence that was presented at trial. And I have a reasonable belief that the issues related to what evidence was allowed in, what things were presented to the jury, what arguments were made in closing statements, may have caused the jury to find him guilty over what they should have made their decision on, which should have been or could have been a reasonable doubt. All these other people, nobody saw anything. It's been 20 years, give or take. I don't remember exactly how long it was. And, she only came forward now, and no physical evidence. I have a reasonable doubt. It's not unreasonable to have a reasonable doubt like that. And I get it. If you think that Earl did it, great. If I was judging things based on everything I knew about Earl outside of the trial, I'd think Earl did it. But based on what was presented at trial, solely based on what was presented at trial, I would have a reasonable doubt. And so I think a jury should have had a reasonable doubt. Now you're saying, John, you're substituting your own finding of facts with what the jury did. Well, yeah, but I'm taking into account all the procedural errors. Now, the procedure is put in place to make a trial fair. The United States is built on a fair trial where the plaintiff and the defendant have a level playing field. It's an adversarial system. Both sides should have all of the same rules, all the same regulations, and they should abide by them, because the outcome then is fair. And and a fair trial is important because, number one, it gives the victim credibility. If the trial is unfair, you have people thinking, well, you're the alleged victim. It gives the public closure because the public has a vested interest in getting rid of criminals. And the public has a need to know that they won't be falsely accused of something, placed into a situation where the cards are stacked in their favor, and then innocent people get put away. So the public has a vested interest in knowing that only criminals are being put away, that the system is fair, that if the system is used against them, they won't be a victim of the system. And they have a vested interest in knowing that victims get justice. Everybody has an interest in this. The defendant has an interest in having a fair trial, because if the defendant didn't do it, Earl did a lot of things. But the other things he did shouldn't come into play, at least at the finding of guilt portion of trial. Sentencing, absolutely, all that stuff comes in. His past criminal record comes in. his good citizen standing comes in. Like if he's been doing like sketchy shit all over the place, that's stuff that can come in for sentencing purposes. But not for guilt. Because the issue before the court, the issue in front of the jury, is whether or not Earl did the exact thing he's being charged with. The prosecution has to prove every element, not that he's a bad guy, but every element of the charge that he's currently facing, including any subcharges, lesser included offenses. So I hope you understand. I know most people won't, because people react emotionally to this. And remember, the difference between me and the people reacting emotionally to it is not that we both don't dislike Earl. We both dislike Earl. I have a strong distaste for Earl. I've been on record what would happen to Earl if Earl shows up at my home. He's not going to walk away. I have a strong distaste for him, but I separate that from my analysis. When I represent clients, whether I like them or not, I separate my feelings for the client from the analysis. I separate my feelings for the defendant and defense counsel from my analysis. Because a judge isn't going to share my particular distaste. A jury isn't going to share my particular liking. They have their own likes and dislikes. And they shouldn't have any knowledge outside of what's presented at trial of the defendant or the plaintiff. So that's why I come to the conclusions I come to. It's not because I think Earl's a great guy. Entirely the opposite. Despite me not liking Earl, I have looked at the issues, and you can go back and watch all my previous videos where I have all the facts and stuff more fresh in my head, and I cover all the procedural issues and things like that. But I'm going to just be honest with you. I'm not going to be persuaded at all by anybody telling me their opinion of guilt or innocence in the comments. That is irrelevant to me. It doesn't matter. You know, I mean, if you feel a need to say it, I'll heart your comment and move on. But you're not convincing anybody with your Earl fucking did it. Ugh, he's getting what he deserves. Ugh. You know, like your legal analysis is shit. Another issue that was raised a couple times in the comments on my last video was that non-citizens shouldn't have freedom of speech. And that may be your opinion. Great. But the Bill of Rights extends to persons, not to citizens. It extends to persons. And non-citizens inside the territorial boundaries of the United States are persons. You may disagree. Great. But they're persons. And there is a long, unbroken line of cases that have held that non-citizens have the appropriate rights, including First Amendment rights. I mean, they don't have the right to vote, but they have, Fourth Amendment rights. They have Fifth Amendment rights. They have First Amendment rights. I mean, it's like they do. And so your opinion might be that they shouldn't, but if you're going to jump into my comments and tell me they don't, well, you're dumb and you're wrong, and you're just as bad of a legal scholar, constitutional scholar as Chili DeCastro. I mean, you're no different at that point. Anyway, I've rambled long enough. Thanks for watching. Have a great day.